Hello, good morning. This is Dr. Iftikhar Ahmed Ansari, Department of Political Science, Aligarh Muslim University, Aligarh. Now, I had been talking about the theories of origin of the state, and in that respect, we had started social contract theory. And in social contract theory, so far, I have talked in previous lecture about the theory of contract that is given by Thomas Hobbes. And today I'm going to talk about John Locke, one of the theorists of social contract, who provided us another exposition on what the social contract was. So John Locke, from 1632 to 1704 in England. So here we find if Hobbes, who championed the absolute sovereignty of the monarch, we find in John Locke another English political philosopher who espoused the cause of limited monarch in England. Now, his theory was a justification of the revolution of 1688 and a deposition of James II, who was ruling at the time. So, the theory of John Locke is found in his creation, that is, two treatises on civil government, published anonymously in 1690, wherein he defended the ultimate right of the people to depose the monarchy from his authority and, if ever, deprive them of their liberties and properties. So, Locke, in reality, he sought, as he himself admitted to, establish the throne of great restorer, that is the present king at the time, King William, and make good his title in the consent of the people. And mark the words in the consent of the people for this form, the keynote of Locke's theory. Civil power, according to Locke, is based upon the consent. That was the main idea. Now, he elaborated his theory of contract again through the similar fashion, similar pattern, which was provided by Thomas Hobbes, through human nature, then state of nature, then contract, and the formation of the state itself. Now, talking about human nature, according to Locke, man is both social and rational. He is rational because he can live with the laws of nature peacefully, and he is social because even without any authority, he can live in society in an orderly way. So Macpherson says we are accustomed to think that Locke held men to be essentially rational and social. Rational, that they could live together by the law of nature, which is reason, which is at least through imprinted on the minds, is knowable or knowledgeable to the individual through his reason and without the help of any revelation. And social, in that they could live by the laws of nature without the imposition of rules by a sovereign. So, according to Locke, even without the state and authority, the individual can live in a moral order. So, uh, individual is not selfish, he's not egoistic, he's not competitive, and he's not aggressive. So individuals give due respect to the life, liberty, and property of other individuals living in society. So Locke did not take a dark view of human nature as Hobbes had taken and had done, because of this time where at the time there was peace around and there was orderliness, and it's all life was settled basically, unlike those of Hobbes's, who wrote near a peaceful revolution that had taken place during the time of Locke, whereas Hobbes was trying to analyze a political life after a violent revolution. So the state of nature, he, in this nature, Locke too started with the state of nature, but his state of nature was pre-political, not pre-social, as it was the case with Hobbes. As such, it did not present to him such a dismal state of affair as it had done to Hobbes. Locke's men in the state of nature was he was and they were neither selfish nor self-seeking nor aggressive. He was social, he was sympathetic towards others because of the law of nature, which was the law of reason, directed him to do so. So, under the law of nature, as Dunning says, of which reason is the interpreter, equality is the fundamental fact in man's relation to one another. But equality for Locke was not what it was for Hobbes. In Locke's state of nature, man was equal and free to act as they thought fit, but within the bounds of the law of nature. And the bound of the law of nature enjoined upon him not to harm another in his life, health, liberty, or possessions. So, Locke's state of nature was a state of peace. It was a good with mutual assistance, preservation, as he himself put it, in contrast to a state of enmity, malice, violence, mutual destruction, as he described Hobbes's state of nature. So, talking about natural rights from the law of nature as it prevailed in the state of nature, flowed, according to Locke, certain natural rights: a right to life, right to liberty, and a right to property. So, the right to liberty, he says, was man's right to do whatever he wanted to do, as long as that was not incompatible with the law of nature. And the right to property was the man's right to anything with which he has mixed his labor, provided he made good use of it, since nothing was made by God for man to spoil or destroy. But the law of nature did not create rights alone, it imposed corresponding obligations as well, because rights had a law which obliges everyone, and reason, which is that law teaches all mankind who will but consult it, that being all equal and independent, no one ought to harm another in life, health, liberty, and possession. So that is, everyone in the state of nature, while valuing his own life, liberty, and property, must also value and respect the life, liberty, and property of others as a matter of duty. Now, such a state of nature in which men enjoyed rights and acknowledged their duties was both moral and social. Now, in that condition, where was the need for civil society or the formation of the state itself? Unfortunately, the peace was not secure in the state of nature of Locke. It was constantly upset by the corruption and viciousness of denigrated men. Now, this ill condition, Locke said, was due to three important wants which remain unsatisfied in the state of nature. That is the want of an established, settled, or known law, the want of a known or indifferent judge, and the want of executing power to enforce such decisions. Now, all such ill conditions, Locke asserted, was full of fear and continuous danger. In order to escape from all this and to gain certainty and security, men made a contract to enter into civil society and the state. Now, this contract was of all with all, and Locke named it a social contract. Now, the social contract put an end to the state of nature and substituted it by a civil society or the state. Each individual contracted with each other to give up some of the right he possessed in the state of nature, and all agreed to give up everyone his single power of punishing to be exercised by such authority alone as shall be appointed to it amongst them, by such rules as the community or those authorized by them so to that purpose shall agree on. So the social contract was accordingly no more than a transfer of certain rights and power, so that men's remained, remaining rights could be protected and preserved. Secondly, the contract was for limited and specific purpose that was given up, was transferred to the community as a whole and not to a man or assembly of men as Hobbes had held. Now, in this way, Locke recognized and established the sovereignty of the people, and that the state existed for the people who formed it. They did not exist for it. So the contract was basically, if men were objects for which the social contract was necessitated, that is to create a positive law, establish a known judge to create an authority to enforce such decision, the society in its corporate capacity established the government and authorized it to make positive laws consistent with the law of nature, appoint impartial judges to decide disputes and to enforce their decision. So there was thus two contracts according to Locke, though he did not say so explicitly. The first was a social contract which brought into being a civil society or the state, and the second was a governmental contract when society in its corporate capacity established a government, selected a ruler to remove the inconveniences or ill condition which necessitated the formation of civil society or the state. The second contract or the governmental contract was subordinate to the first inasmuch as government was only a fiduciary power to act for certain ends, and its authority was confined to securing those ends. It was limited, moreover, to the condition that it was to be used in the exercise of established known law. If the government failed to secure the ends for which it was created, to which it had agreed, or did not exercise its authority according to the established known laws, the community might dismiss and appoint another government in its place. So, talking about the nature of contract, here Locke establishes the inherent right of the people to revolt against the authority of the monarch if he ever abused the terms of the contract to which he is a party and ruled arbitrarily, ignoring the established known laws made by the representatives of the people. So, the purpose of Locke is served by making monarch a party to the contract. He limits authority and subordinates it to Parliament, the supreme power of the Commonwealth. Now, three conclusions flow from this premise that the government exists for the good of the people, and secondly, that it should depend on their consent, and third, that it should be limited and constitutional in its authority. Now, if it is not for the good of the people, if it does not depend upon their consent, if it is not constitutional and exceeds the authority vested in it, the government can be legitimately overthrown. So Locke recognized the existence of three powers in the civil society or the state. There is, first of all, the legislative, which he called the supreme power of the Commonwealth. Legislature, he held, was the instrument through which the will of the community was expressed. Now, since the expression of that will preceded and determined its execution, that department of government which carried out the laws must be subordinate to the department that made them. Although for Locke the legislature was unquestionably the superior power, yet it was not sovereign. The idea of absolute, unlimited, and inalienable sovereign power in any human hands found no place in Locke's theory of social contract. Now, behind the supreme legislature stand the people, the final embodiment of power. So, the community, Locke said, perpetually retains a supreme power of saving themselves from the attempts and design of anybody, even of their legislators, whenever they shall be so foolish or so wicked as to lay and carry your designs against the liberties and properties of the subject. Secondly, there was the executive, which, according to Locke, included the judicial power. So the legislature need not always be in session, but the executive must be. Hence, he concluded they, they come often to be separated. There should be a separation between the legislature and the executive because it may be too great a temptation to human frailty, which is apt to grasp at power. So, this is how Locke enunciated the doctrine of separation of power, which is enshrined in the American Constitution, though it is Montesquieu, not Locke, who is the author of the famous classification of powers into executive, legislative, and judicial powers. So, the third power that Locke considered is that of to be called a federative power. That is the power that made treaties. Locke has not made Locke has not more to tell about the federative power except that it is much less capable of being directed by positive law and so much necessarily be left to the prudence and wisdom of those who are entrusted to manage it for public good. To sum up, we find the following important points may be uh, noted in Locke's doctrine of social contract. First is that Locke's state of nature is pre political rather than pre social. Secondly, his state of nature is not that of perpetual war as it is with Hobbes. It is the state in which men are equal and free to act as they thought fit within the bounds of the law of nature. The law of nature is the law of reason, and the law of reason established certain natural rights and recognized certain duties. Now, this state of nature in which men have lived and acknowledged duties is moral and social in character. But certain inconveniences are experienced in the state of nature. Now, these inconveniences are three in number. Certainly, in the application of the law of reason, absence of common judge to decide dispute according to the established law, and no proper authority to execute those laws. So, to escape from these inconveniences and the continued danger of fights, wars, and confusion accompanying them, men, through voluntary compact, formed a political community, and the communities instituted governments. So, according to Locke, there was two contracts: social contract, government contract. The first put an end to the state of nature and substituted it for a civil society or the state, and second is made with a view to forming the government and selecting a ruler. But the second contract is subordinate to the first, since the creation of government by a community, followed by a prior organization of the community itself, the community can change the government without dissolving itself. Then the ruler is part to the contract, and there is not a surrender of rights as with Hobbes, it's only the transfer of a few given rights. So, law is not a command of the sovereign, as Hobbes had said. According to Locke, law must be the expression of the will of the people, and it should be consistent with the law of reason. Locke makes consent of the people the source of all governmental authority. Locke concedes to the people the right to revolution, and thus the ruler can be deprived of his authority if ever he fails to fulfill the terms of his contract. So, finding the relation between the state and individual, we find that Locke was, in fact, a great champion of human rights and gave the theory of natural inalienable rights to the individual. And he maintained that it was the obligation of the state to safeguard these natural rights of the individual, and especially his right to property, which meant life, liberty, and property itself. So the state is not an end in itself, it comes into being with the object of defending and safeguarding those rights. So the state is man made, limited, established to serve and defend the individual's rights. If the state does not perform these services, then people can overthrow the political authority. In this way, Locke is a thoroughgoing individualist who limits the sovereign of the state by the rights of the individual. So, to Locke, the individual is prior to state and is the end of the state, whereas the state is a means to serve his ends. So, state is a convenience, it's not a necessity, it's merely a servant of all powerful individual. But the question arises, which individual? The answer is possessive individual who has property to be defended, who is rational, who is moral. So the individual being rational and moral and social even before the origin of the state does not owe his rationality, his morality, and his intellectual development to the state and is independent of the state in these spheres. So state is not the creator of rights but only safeguards them. So individual is basically a possessive individualism as being clarified by Locke here. So the obligation of the individual to the sovereign arises out of his own consent. And Dunning says the most distinctive contribution of Locke to political theory is his doctrine of rights. However, it cannot be denied that the most important natural right to Locke was that of right to private property. Maxey says the chief object of political society, Locke repeatedly affirmed that the protection and preservation of property was the main right, and because of this, Locke is the most important philosopher of possessive individualism as well. Now, evaluating Locke's theory of contract as an origin of state, the most distinctive contribution of Locke to political theory is his doctrine of natural rights, life, and liberty. And property as well. So he holds an inalienable right of every individual. So, and for which the civil and political society is constituted is to secure these natural rights. And the attainment of these rights is made possible through the agency of government. So Locke accordingly makes a clear distinction between the state and the government, which we find absent in the case of Hobbes, and he introduces the theory of consent. Now, this theory of consent was not there in Hobbes's case, which, in the words of Lasky, now occupies a permanent place in English politics. Now, according to Locke, government holds powers on the condition of and derives its authority from the consent of people whom he ultimately holds sovereign. So he emphasized that the sovereignty of the state is not the sovereignty of a ruler, and the will of the state may limit the will and actions of a ruler. So, a government for Locke is a trust. The authority of government must be exercised for fulfilling the needs which necessitated the formation of the civil society. And if the government fails to function properly and in accordance with the wishes of the people, then the community has the power to dissolve it and substitute another government in its place. Now, the happiness and the security of the individual figures not as an essential to the perpetuity of a government, but as the end for which alone government is ever called into existence. Now, talking about the defects of the contract theory given by John Locke, the main defect in Locke's theory is that he altogether ignores the concept of legal sovereignty. In the words of Gilchrist, to use our terminology, Hobbes gives a theory of legal sovereignty without recognizing the existence and the power of political sovereignty. And Locke recognizes the force of political sovereignty but does not give adequate recognition to the legal sovereignty. Nor he is sure where sovereignty really resides. He speaks of supreme power of the people at the one time, and at another, he talks of the supreme power of the legislative assembly. Similarly, his view on the state of nature and that the people inhabiting it made two contracts are incredible. Locke's contribution to the theory of natural rights has also been subjected to severe criticism. For example, Bentham remarks that the concept of natural rights prevailing in the state of nature is simply nonsense, rhetorical nonsense, and nonsense on stilts. All the same, Locke is considered the ideological father of American Revolution. Now, there are many inconsistencies and ambiguities and serious defects in his socio-economic and political theories. The main criticism of his political theory are as follows. Like first, his view on human nature are unclear. His theory is ambiguous. His state of nature is not clear, and it is not clear whether it is a state of peace, of war, or pre-social, or pre-political. So his doctrine of consent, power as trust of the people, the majority rule principle, and the representative government idea are all unclear. I mean, he did not clarify it anywhere what he meant by that majority rule, or what he meant by representative government, or what he meant by the power as a trust of the people, or the doctrine of consent itself. He simply mentions it. So it is not clear what exactly he meant by that. Now, it's not clear as to how many contracts are there. He did not specify that two contracts were made, although he did talk about two stages in that contract. From there, we surmise that in fact, two contracts were made. And then his theory of sovereignty is confused, and he is unable to clarify in very clear terms, as Hobbes has clarified what sovereign stands for and what it means, and what it means by sovereignty itself. Now, he is not clear here, Locke, when he talks about sovereignty, where it resides, whether it resides in the legislative assemblies, whom we consider as the center where will of the people are created, or it resides in the people themselves who stand behind the assemblies. So its residence, where it is, or what it constitutes, he has not very clearly mentioned and specified. And then he maintains a difference between legal and political sovereignty. Legal sovereignty, as given by Hobbes, and political sovereignty of people. He makes a difference here. He emphasizes political sovereignty, although he neglects completely the legal part of it. So Hobbes overemphasized legal sovereignty, and Locke, in fact, the political sovereignty. He emphasized political sovereignty, neglecting the legal part. So his Theory of natural rights is virtually a theory for defense of property. So in natural rights, he emphasizes the one right, and that was the property, and he was more concerned about securing this right to property more than any other right. That is what is surmised from what he has presented. So his political theory is less of a state and more of a revolution, as he time and again emphasizes that individual have the right to revolt in case of breach of trust by the sovereign power. So the purpose of Locke might have been to constrain the monarchy and give the ultimate power to the people and their consent to rule. But finally, what he has come up with a contract, and this contract theory is another addition in the evolution of the earth and the origin of, sorry, evolution of the state and the origin of the state itself. So, with that, I come to the end of the presentation on the social contract theory as the origin of the theory of the state. Thank you for watching. Thank you very much.